I'm going to go ahead and welcome everybody to the Will Brownlee Fair Housing and Emotional Support Animal Update, sponsored by Loebsack and Brownlee. So, Will, thank you so much for joining us today, and thank you to Loebsack and Brownlee for hosting this for us and allowing us to offer this as a member benefit. So we're super excited about that. Before we get started, just a couple of housekeeping things. If you have a question throughout the presentation, make sure that you put it in the Q&A at the bottom and not the chat. Also, I would say you guys will be getting an email about events that are going to be happening in May. Again, all these events will be virtual as far as committee meetings and additional webinars that the WAA will be hosting. So just tune into our website and pay attention to emails because we have a lot of fun and interactive things coming down the pipeline for May. But I don't have any other announcements, so I'm going to turn this over to Will. And again, thanks to Loebsack and Brownlee and Will Brownlee for doing our fair housing and emotional support animal update. Thanks, Will.
All right. Welcome, everybody. It's really good to see you all again in this format. First thing, April. We're celebrating Fair Housing Month this month. Just want to mention that it's still April, believe it or not. And so happy anniversary to the Fair Housing Act. This month in particular, it's 52 years since it was passed back on April 11th. So very timely by WAA to have this seminar during the month of April for that reason. And we all celebrated, and it's, I mean, unless you are way past your prime, you've lived your entire life and your entire career with the Fair Housing Act being in existence. I think we're all thankful for that. Before I teach any fair housing class, even one that's a hot topic class, because I don't know if my audience may have been in the industry for 6 months or, or 50 years. And if you've been in the industry for any amount of time, goodness knows you've had your share of fair housing refresher courses, whether in person or sitting in front of a monitor like this one. But I find that it's always good to just give a quick 5, maybe 10-minute quickie review of the protected classes. Some of you may say, geez, I've only heard this 50 times, and I get it. But for me, even as an attorney, it resets my brain to start thinking about fair housing. And then it's easier to flow into the other topics that we're going to cover today. So really quick, I'm going to go through the basics of protected classes under the Act. And those basics.
Will, could you speak up just a little bit? We have a couple people are having a trouble hearing you. Sorry to interrupt.
Okay, I'll get a little bit closer if that's a little better.
That is, thank you.
Absolutely, thanks. 7 main classes under the Fair Housing Act. For those of you, don't get hung up on the words protected classes. Instead, think of them as reasons you cannot treat people differently, that you cannot discriminate based on. And those 7 areas are race, color, religion, sex/gender, national origin, familial status or families with children under the age of 18, and disability. And we're going to break those down really quick just to, again, reset all of your minds and mine. Protected classes, first one, race. It's generally regarded as a class or kind of human population having a common origin, certain physical traits and appearances. And a lot of people, even people in the fair housing world, even HUD, sometimes interchangeably use race with color. And that's actually technically not true. Race is a broader swath than talking about people's color of their skin. Race is a broader concept. Think area of the world where you or your ancestors may have originated. Caucasian, African, Asian.
Will, sorry to interrupt, are you clicking through slides? Because we still see your first slide.
Sorry, guys.
No, sorry to interrupt you.
Let me see if I can fix that. Again, monitor problems. Pardon me, guys. I think I see the problem. You guys are on another monitor on my end. How about now?
I don't see a screen at all. I see you. You.
Sorry, guys. Huh. Tell you what, I'm going to unplug the other monitor, go to single monitor, and I think that's my problem. How are you guys now? Do you see it?
No.
Oh my goodness.
Hey, Will, are you sharing your screen?
Hit the little green button at the bottom.
Well, let me see.
Because it usually will put like a box around it if you're sharing it, and you should see yourself get real small on the right-hand side. There, it's doing it now. Hold on. There you go. So, and you have a little bit of another screen showing, so you might want to drag that down. Oh, there you go. There we go.
Sorry, guys.
There it is.
Technical difficulties. We got it. We're good.
Okay. So this is all the classes again, now that you haven't seen. Race, color, religion, sex, gender, national origin, family status, and disability. But I meant you to see earlier. So race. Definition of race, now that it's on the screen. Again, the emphasis on the origin of your ancestors, common origin. Not to be confused with color in any way. Sometimes the classes are interchangeably used, even by HUD sometimes, but that's not true. Color, though, completely different classification. It's based on someone's skin pigmentation being lighter or darker than someone else's. And I've always liked to think that color is the broadest of all the classes. I mean, there's roughly 8 billion of us on the planet, 8 billion shades of color. Some people have even said in the past in classes I've been in, or even cases I've been involved in, where I'm white, I can't discriminate against a white person, or I'm black against a black person, or I'm Latino. And actually, when you think about it, every human being is a slightly different shade from each other, because we're all based on skin pigment, and that is a wide variability of 8 billion different people. Very easy to discriminate, which I'm going to get into later, is why we always emphasize in fair housing about consistency of treatment. It's very easy to trip that line, especially in color. Now, religion. Religion is generally defined as an organized system of beliefs or devotion to a religious faith or similar observance. The ability to practice religion, have religion, is certainly protected. You can't discriminate openly against someone's religion. You can't put up a sign in the front of your clubhouse saying, well, no Catholics or no Buddhists or etc. Again, that's an open discriminatory intent against a religion. Also, one caveat about religion: religion is not like disability. You do not have to have an accommodation for religion. Some people confuse that with employment law, where you generally do have to have an accommodation for religion, but that's not true in the fair housing world. It's merely a basis that you cannot treat people differently. Now, national origin, generally defined as exactly how it sounds. It's individual's place of birth or their homeland, where they are from, where you are from, where did you immigrate from, where is your family from, are you from Russia, or are you from Great Britain, are you from Italy, are you from Zambia, are you from Zimbabwe, are you from Vietnam? You get my point. You're talking about an origin that's nationally based. The funny thing about national origin is that sometimes this is used interchangeably, even by HUD on its own housing discrimination forms, where someone will say, well, gee, I was discriminated based on national origin because I am Latino. Well, Latino per se is not necessarily a nation. That is more of a race. It's an area of the world, even arguably a language. So anyway, national origin is fifth class. The next class, and one we're going to get into in more detail later today, because it is a definite hot topic for discussion because HUD's made it so, is the fifth class. And it's mostly based on differences in gender, male versus female. However, it can include sexual harassment as well, treating people differently, harassing them on the basis of differences in gender from the person doing the harassing. And if you are at a HUD subsidized, financed, or insured property, the category of sex also includes sexual orientation, gender identity, and marital status. Now, currently, those protections are not available on the federal level or at the state level in North Carolina as of yet. However, they are available for HUD subsidized finance and insured property. Now, the sixth classification is family status. And a lot of people get hung up on the word family because when they hear family, they think, well, what's family mean to me? Is it a cousin? Is it an aunt? Is it a grandma? And it's more focused than that. When you hear family, you should instead think children, because that's really the focus of the family status class. It's based on the presence or the expected presence of children under the age of 18 years old. Now, if you're dealing with a family where all of their children are 21 and over, 25, 30, you're talking about a family in the societal sense, but you're no longer talking a family in the fair housing sense. Again, this class has nothing to do with family, but everything to do with children under the age of 18. And it has to do with their presence, whether they're actually there or going to be in the home, or the expected presence. So when you're talking expected, you're naturally including pregnant women, because of course, that is the expected presence of children. It's even broader than just that. It can also include individuals seeking to secure the custody of children under the age of 18. So you can also include custody in terms of a divorce proceeding or a separation, where you're talking two parents having custody or seeking custody of a child under the age of 18. Also includes adoption, of course, trying to adopt a child. Or if you are a foster parent and you're fostering a child under the age of 18, all of those are encompassed in the family status classification. And I could teach a separate fair housing class just on family status, because family status is often one of the more misunderstood classes, because a lot of people don't think of it in the same vein as race or sex or color. But family status is every bit as important as the rest. And last, but definitely not least, and we will be discussing it more today, is protected classes in terms of disability, the seventh and final class. And disability, as we'll discuss a little bit later, out of all of the classes, is the most litigated class by far nowadays. At the birth of the Fair Housing Act, before disability and family status were added in 1988, race reigned supreme, generally. Race was probably better than 50% of all the filed cases. But as disability has evolved since 1988, especially with reasonable accommodations, especially with animals, which we'll try to touch on before the end of the class, disability now accounts, according to HUD's most recent numbers, roughly 60% of all filed cases in America now is disability-based. All the rest of the classes, race and gender on down, together only make about 40. So very important. So what is a disability? It is the physical or mental impairment which substantially limits one or more of a person's major life activities. That is the textbook definition of disability. And you'll notice the two main words in that definition. It's physical or mental. Now, if you've been in the industry at any length of time, I think it's fair to say we all get physical. We all understand physical. But because we see somebody who's clearly suffering from a disability where they are missing a limb, let's say, or they are missing a certain one of their senses, if they've lost their sight, if they've lost the ability to speak, something physical. If they've lost a limb and they're hobbling around, or they're physically unable to move, or they're confined to a wheelchair, those are physical and very easy to detect because anyone with a set of eyes can view that. Mental is much broader and is the one that likely generates the most litigation, because mental is what's going to lead us to the gateway of emotional support animals and service animals. And again, it's defined as an impairment which substantially limits one or more of a person's major life activities. And without getting too deep into weeds, what is a major life activity? Again, very simply put, and it's a very simplistic way of looking at it, but it's something that you would miss if you could not do it. It would affect something you consider major, your ability to function, to navigate the world, to conduct business, to run your families, to work. Anything that interferes with those activities would be viewed as an impairment of that major life activity. And the reason that disability is special, it's different from all the other protected classes, is that a person with disabilities have special rights that the other 6 classes do not have. and that is the ability to request a reasonable accommodation, i.e. bending of or changes to or ignoring completely certain rules or policies that you may have as a landlord. And also reasonable modifications, which are viewed as changes to physical structures, where someone needs a ramp where there isn't one, or a curb cut or a parking space where there isn't one, or widening of a door, or installation of some modification either in the home or serving the home that will assist them in their disability. That's a modification versus accommodation. Again, we could do this for a long time, but I wanted to do just 5 or 10 minutes tops of these classes. Now, moving forward, some of the hot topics that we have to discuss, there's just no way around it, obviously, is COVID-19 and impacts involving the Fair Housing Act. COVID-19, we're all living with it and the effects of it, and I'm sure we're all battle weary from the quarantines and the changes in our lives, but FHA is no exception in that aspect. And there's certain impacts that it has and has had already and will have moving forward to how the Fair Housing Act is applied and how it affects our industry moving forward. HUD put out a statement on COVID and Fair Housing Act, shortly after COVID became a reality and quarantines went into effect all over the country. And generally, HUD's statement, which I'll have a link to that at the end of the seminar on a separate slide that y'all can view, save, look at, generally wanted to focus all of us that, number one, HUD is sensitive to the fact that COVID's existence, obviously, but they wanted to remind all landlords that under the Fair Housing Act, that we're still responsible for the complying with it and to be mindful of it in all of our policies that we set forth moving forward. And it didn't give a specific directive per se. It's more of a gentle reminder that HUD was taking us by the hand saying, remember landlords, you have a duty to honor the Fair Housing Act, not discriminate against any of the 7 protected classes, and to be sensitive to that in your decision-making moving forward, ranging from payments, ranging to evictions, to waiving of late fees, and how you approach those sorts of things. And that leads me to the next topic, which is the effects of the CARES Act. Now, I don't want to turn this seminar into a CARES Act training. Doubtless, y'all have seen your share of CARES Act webinars that have put on by Chris Loebsack, Brownlee Whitlow Prate, and how that can affect your day-to-day operations. Needless to say, CARES has a number of pieces in it that are key, particularly for those of you who may be on this webinar who have a covered property. And by that, I mean a property who has any sort of federal assistance in terms of financing or insurance to become what the CARES Act refers to as a covered property with covered dwelling units. Someone who has any Fannie Mae, Freddie Mac involvement, any sort of tax credit, et cetera. And again, I'm not going to get into CARES Act specifically, but just as a very brief, broad overview, be mindful that if you are property that is covered by the CARES Act, that you have certain obligations to comply with, including the no charging of late fees during the moratorium period, which is around 120 days from the passage of the Act on March 27th. That takes us roughly close to the end of July, so no late fees for those affected properties. No evictions for those covered properties as well during that moratorium period of 120 days. Those are the highlights, of course. I'm not going to get into CARES any further than that, but be mindful of that because your treatment of your residents based on the CARES Act, you want to make sure to be compliant with the law and not step outside of it. But I think, and the number one takeaway in this world of COVID-19, CARES Act, is your communications to your residents. And the critical notion that I'll hit in the next slide of being consistent in how you approach your communications with your residents. It is so very important to be consistent. And by that, I mean, a number of you have waived late fees. Even those of you who are on properties who are not covered by CARES, you don't have a federally financed mortgage. A lot of your companies or owners have made the strategic decision, maybe the merciful decision that, hey, we're not going to charge late fees during this interim period. And that's fine. It's a very nice thing for you and your ownership and your management company to do. Keep this in mind, however, is that you want to be uniform when you do that. And I'll cover that a bit more in the next slide. And the same holds true to those of you who may have engaged or thought about engaging in payment plan agreements with your residents as well, in terms of entering into those settlement agreements and payment plans. And I'll get into that a little bit more on the next slide. So in your communications with your residents, whenever you're talking about payment plans, waivers of late fees, waivers of even NSF fees, I've seen landlords do that, even where they're not covered by the CARES Act. That's perfectly fine, of course. But the key is to always be consistent and uniform in how you communicate that and what your policies are. And here's what I mean by that. I've seen some management companies, some clients even approach us or other attorneys asking, well, how are we going to approach waivers of late fees? How are we going to approach payment plans for people who need them, who've lost their job? Are we just going to, some have even suggested, gee, we're just going to take this a la carte. We're just going to take it, or ad hoc is a better way of putting it. We're just going to take it as a to request it. We're not going to offer it. And I would respectfully suggest that you don't go down that road. Instead, if you are going to have a policy of payment plans, you should craft a policy as a company, as a management company, as an owner, to offer that to all of your residents on site. Or don't do it ad hoc. Don't do it per person. If you do that,
Hey, Will, you're frozen.
and then you're off to the races.
Well,
Hey,
you
Will,
froze
can you-
for a few minutes.
Hello?
We can hear you now. You froze for a few minutes.
Okay, sorry about that. Apologies for the internet connection and a bit weirded out all of a sudden. Hopefully you heard the comments about consistent uniform communication, how you have to offer your payment plans, waiver of late fees, the best practices to communicate it to all of your residents. Don't do it one person at a time. Don't do it based on who walks into the office and asks for it. If you're going to come up with a policy and if you're going to approach a payment plan, go ahead and release it to all of your residents. And I know a lot of you may not want to do that. Your companies may not want to do that, but it's critically important because there's just no way to avoid the impression of differences in treatment if you offer it to one resident who came in to ask, and then they share that with someone else who was oblivious to this idea of a payment plan being available until another resident told them. And the impression is going to be, well, I'm a different gender, I'm a different race. And then you're off to the races in terms of fair housing, because fair housing is often based on the perception of differences in treatment. And then you'll spend the next 6 months or a year defending a claim based on that perception, whether true or not. The best way to avoid that is just to offer it according to a very carefully crafted written policy and plan that you distribute to all of your residents. That's the one way to avoid these perceptions of differences in treatment. I don't want to hit that too hard, but it's critically important that you do not do it, you don't do it ad hoc. Along those same lines, NAA has a series of best practices that they published and distributed to the affiliates, and I'll have a link to it at the end of the presentation, where they echo these same principles. Please be consistent in how you waive late fees, communicate uniformly to your residents. Same thing about evictions, what your policy is going to be, communicate that across the board. If you are at a non-CARES property and you're eligible to file eviction before the end of the summer. So NAA's best practices is an excellent guide, an excellent place to start to cement those ideas. And if your owners or management companies don't believe you, point them to that. as a good guide of where to go. Also, if you do not already have one, and I don't want to push this too hard, but many of you who already use the NAA lease forms on Blue Moon in particular, they have a waiver of late fee form, which is a very nice, consistent means of informing your residents that you've decided to waive late fees. If you've decided to do that across the board, great. That form is an excellent resource, and I do recommend that you go look for it. Again, for NAA lease users, there's a form to do that. I believe AA&C may have developed their own form with Brownlee Willow Parade as well. That's also available for those users. And also similarly, NAA has a payment plan agreement form that's, again, not required, but an excellent resource to use in terms of developing a consistent strategy of approaching your residents and offering it according to a set structure that you don't deviate from. You keep it consistent and uniform and apply your policies through that form. If you don't already have a payment plan, for those of you who want to engage in that sort of thing, this is a great place to start without reinventing the wheel for your company. Now, sexual harassment. And I know time is moving quickly. We're already at about 11:33. I'll try to make this as fast as I can. Another topic that is a focus that I want to hit on this month and for this webinar is sexual harassment, mostly because HUD itself has been focusing on this topic and pushing it on their website during this last month. If you see the graphic in front of you, this is a copy of HUD's graphic that they released earlier this year, where their emphasis and their focus now is on sexual harassment and how it, of course, is illegal. And I've already mentioned that earlier under the category of the protected class of sex. But I want to emphasize this a bit more just because HUD is being very sensitive to it and mindful of it, and that means you should be too. So this is a graphic from HUD's own website that they've also sent around the country, you may see it again, and don't be surprised to see it. And you'll see some of these quotes that are in the hands. I don't feel safe anymore. I'm scared. My landlord's comments are sexual. I feel violated. Who can I call? I don't know where to go. Who will believe me? And they reference sex for home repairs in some cases, extreme cases. And just be mindful of it. But so let's discuss sexual harassment really quickly, as fast as I can, and leave time for Q&A. There's two primary forms of sexual harassment that HUD is focusing on in its latest publications. And one is called quid pro quo harassment. And I'll get into what quid pro quo means in a minute. And also a hostile environment. Some of you may think of it as sexual harassment in a hostile work environment. This is very similar. This is a hostile environment in terms of your housing with the landlord and management company. So let me break that down just a bit more. When HUD talks about quid pro quo, this is HUD's definition of what that term means. Now, quid pro quo is Latin for, essentially you give me things, I give you things. It's an exchange, one for one. And in terms of sexual harassment, it refers to whenever a housing provider requires a person to submit to an unwelcome request to engage in sexual conduct or similar as a condition of obtaining or maintaining housing or housing-related services. And here's a few examples. Now, in our industry, especially those on this webinar who have professional training like this, who've gone through their share of fair housing training every year, these may be extreme examples, but these are ones that are from HUD's own website that they are focusing on and I'm sharing with you. For example, a landlord tells an applicant that they won't rent to them unless they have sex with the landlord, or, let's do something a little less extreme, go out with the landlord on a date, etc. Anything in that spectrum could be a possible example. Or another extreme example, the property manager decides to evict a resident after they refuse to perform sexual acts, or again, in a less obvious one, they refuse to go out on a date when propositioned or asked. That could be viewed as sexual harassment. And last, if you have a maintenance staffer who doesn't want to make repairs unless they ask for, nude snapshots, videos, what have you. Or again, it could be less more innocuous and more like a date. I'm not going to go out with, unless you go out with me, I'm not going to come fix your your toilet or your faucet. These are extreme examples, but this is what HUD considers quid pro quo. You give me things, I give you things, and it relates to some sort of basis on sex. And again, I want to take my time a little bit more. It's not just sexual acts that are involved. We're talking any differences based on gender. So if the person who is the landlord happens to be one gender, male or female, and they are propositioning another person, male or female, you already have a difference based on sex. And even where it's same sex, if you are proposing to engage in sexual conduct or things that can be viewed as intimate, that also sexual harassment quid pro quo. Now, next, hostile environment. Different than quid pro quo. It's not, you give me things, I give you things. It's the overall environment that HUD's concerned about, where people, and I'll just read HUD's on definition. It occurs when a housing provider subjects a person to severe or pervasive unwelcome sexual conduct that interferes with the sale, the rental, the availability, the terms, conditions, or privileges of housing or housing-related services. Here are some examples, again, probably more extreme from HUD's own website. A landlord subjects a resident to severe, pervasive, unwelcome touching or kissing or groping. I'll add hugging to that. Something that is clearly unwanted, and if you think about it, under common law, anything that's an unwelcome touching, an unwelcome hug that you clearly don't want, that's generally considered assault and maybe battery. So, it's not just, sexual, it could be viewed as a sexual harassment, but it's also crime in the right context. Next could be a property manager makes a severe, pervasive, lewd comments about a resident's body, maybe how, and you can go from one end of that spectrum to the other. You could talk about how beautiful or handsome that person is, all the way to overtly sexual comments about body parts, etc. Again, that's a hostile environment where a landlord is exposing a resident to those sorts of comments that are not welcome. They could be lewd, they could be distasteful. And again, it all relates back to sex. Also, again, back to the unfortunate maintenance staffer in these examples from HUD. If the maintenance staffer sends a resident severe or unwelcome sexually suggestive text, emails, and then caps it off by entering their apartment without invitation or permission. So they've made an uncomfortable situation, many factors more severe by adding not just the comments, the lewd suggestions, but also the physical presence on top of that. Clearly a hostile environment. Now, many of you who may be on this webinar, many of your companies may have fraternization policies of the sort that you prohibit dating between staff and your residents. And you may think, well, what's the harm in dating, especially if it's consensual, and both parties are fine with it. And, heck, it was the resident who hit on me. And I'm just, I'm a single person. I welcomed it and I liked it and I'm going out with it. And what's the harm, right? And even though the HUD website doesn't go into that level of conversation, their examples are more extreme, as you noticed, between quid pro quo and hostile environment. But I do want to impress the importance of any sort of relationship with a resident can be tricky to navigate because it's a very fine line between having a dating relationship that's consensual to a hostile environment where, what if, for example, what if the relationship breaks up? What if after a few dates it doesn't go well? Turns out you're still the manager, you're still the staffer, you're still the maintenance staffer, and they're a resident. Think of it this way. It is very hard to take that landlord hat off and become just regular citizen who's dating another citizen. It's tricky. And sexual harassment is often based on power and the difference in power between the two parties. When you're the landlord's representative and they're the resident, you're in a position of power. And even if it was consensual, it can quickly lose that consensual status and become a harassment scenario and a hostile environment scenario. So the long story short is fraternization policies, they're not required by the Fair Housing Act. I'm not advocating that they are, but I am suggesting that they may be a best practice because it avoids it. Now, full disclosure, for those of you who know me, I married my assistant manager. I went out with her and I don't regret it. In my defense, Hey, I was ignorant at the time. I was just starting law school, and I didn't know about the Fair Housing Act. And she was a good-looking, beautiful woman, and still is at 24 years later. But you know, jokes aside, laughs aside, I do want you to be sensitive to that, because it can backfire and quickly. So now, I wish I had more time because we're already pushing 11:42, and I want to get in live to questions. So please forgive me, because and Stephanie, this may even be a future separate seminar, but I want to give you at least a taste of emotional support animals and HUD guidance that came out.
And you're pretty good, Will. Real quick, we don't have any Q&As just
wow.
right now, so you're good to keep going.
Oh wow! I'd like to say that I've answered all your questions before you asked them, but I can't take credit for that. So
just wanted to give you an update.
All right, please give me an update. Thank you. Okay, so emotional support animals and HUD guidance. Now, some of you may already know this because the NAA has put out an excellent publications about this and updates about this. And you may have seen seminars already about this, but in terms of emotional support animals, HUD presented some very useful, effective guidance on emotional support animals, and it's almost too much to get into without a standalone seminar, but I just wanted to give you a taste and flavor of it. But before we do, just a quick refresher on emotional support animals and how weird it can get. Whenever I've taught fair housing seminars in my career, anytime we veered into support animals, assistance animals, service animals, choose your term of how you want to describe it. It suddenly dominated the conversation. And there's a good reason for that, because even HUD recognizes now, and this was part of the reason for their guidance, that landlords are deluged. Our whole industry has been deluged with an ever-increasing more variety of topics, and it always circles back to animals and where the boundaries of that envelope are that keep increasing every year. And it was nice for HUD to recognize that and to try to address it and return a little bit of guidance and sanity to the topic. So, but very generally, and again, those of you who had their fair housing training, you already know this, but for those of you who do not or may have forgotten, just keep this in mind. Generally, remember, if you're a disabled resident, you have a general right to a reasonable accommodation where it's needed to assist you with your disability. This can take the form of an emotional support animal, and this is even where animals may normally be prohibited. Some of you have a no pets community, and that's fine. Those of you who allow pets, you may have very substantial fees, pet fees, even deposits. Some of you even require a pet rent on top of that as well. And that's all fine and legal and permitted as a general rule. But keep in mind that those sorts of things, pet fees, deposits, pet rents, these are for pets. They are not for assistance animals / emotional support animals. I'll get to that more in a minute. And again, like I mentioned earlier, the reason why this is a hot topic for HUD and why they had to do the guidance is because roughly 60% of all fair housing complaints now deal with failure to give reasonable accommodations to disabled residents. And a big chunk of that 60% are animal claims, where a landlord unreasonably denied or interfered with that resident's right to have an animal help them with their disability by either discouraging it or charging fees anyway or charging deposits anyway. So HUD wisely and thankfully had to step in to give us some rational basis. On the other end of that spectrum too, some landlords have overcompensated to be compliant and are just letting in all animals without any questions at all because they've been told we're not allowed to ask any questions, just approve them. And even HUD doesn't go that far, and their guidance refreshingly gives a list of acceptable questions that they view as fair game without openly violating the Fair Housing Act, which is very helpful for you moving forward so you don't have to live in fear of asking questions. And so long as they're within the confines of HUD's guidance. So to move on really quick, what was the date of this guidance? And it's dated on January 28th of this year. And the guidance, if you want to write this down, it's also referenced at the end of this handout in the slides that you'll see in the video. It's FHEO, that's Fair Housing Enforcement Office, 2020-01. If you Google those FHEO 2020-01, if you Google that and maybe with the words you know, emotional support animals, et cetera. You'll see any variety of links that will take you to the actual guidance for that you can read in more detail that I can't get into in one webinar, I'm sorry to say, because the questions are too detailed and the analysis is complex. So I wouldn't want to steer you wrong and have you rely on the slides when the publication is far better and more thorough than I can go through in a 1-hour webinar. But the highlights that I want you to be sensitive to. The one thing that the guidance delved into is they presented best practices and trying to assess a person's request for an animal as a reasonable accommodation under the FHA. And by that I mean, the HUD guidance outlined in much more specific terms how you can assess someone's request. Because if someone comes in and says, "Hi, I know you have a policy against pit bulls, but I have a pit bull, and I need it because I have disability, or I need it for clinical depression, or I have bipolar, or they may not get into that level of detail." That would be the textbook method. A lot of times it happens where a resident will move in, they won't tell you they have an animal, and then you'll discover they have one, and then you'll do what you always do. If there's a fee associated with it or a deposit requirement, you may pass that on and ask for it. And then suddenly the inevitable comeback from the resident is, "Yeah, but this is a assistance animal, this is a service animal, this is an emotional support animal." And at that point, over the years, many landlords suddenly have a vapor lock. They suddenly freeze, going, "Oh my goodness, we're talking disability now. Well, I'm scared to say the next thing. I'm scared to ask. I'm scared to even make an assessment of any kind, because if I, quote unquote, ask too many questions, I've suddenly violated the Fair Housing Act." And you may have found, and I have too, that residents know just enough to be dangerous, because Google knows everything, according to some people. And if you Google something more often than not, you'll find the answer that you're looking for, even if it's wrong. And many residents have come to the conclusion of, well, I'm going to get this animal and I'm going to call it an emotional support animal, but no one can ask me any questions. If they do, they're a bad landlord. They violated the Fair Housing Act. And that is some of the pushback that a lot of landlords have experienced over the last 10 or 15 years easily. The nice thing about this guidance is that it outlines the best practices, the questions, and and you'll read it if you, again, Google FHEO 2020-01. You'll see there's a very a nice logical progression to the assessment. It's almost like a choose your own ending of your own book format, or a flowchart format. It will ask, look, is this animal for a disability? If it is it, or is it trained to perform a certain task? If not, then it still may be an emotional support animal. Ask these following questions. If it is clearly trained for a specific task, then it may qualify as a service animal. And it goes through some analysis to distinguish between a quote unquote service animal and an emotional support animal. Spoiler alert, they all get to the same place eventually, because whether you are a quote unquote service animal doing a specific task, or you're an emotional support animal that provides some therapeutic support for the disability, particularly mental, you're going to get to the same place generally, which is they are going to qualify as a reasonable accommodation, assuming certain factors are met, assuming they can establish the connection between the need for the animal and the disability that they have. This guidance does an excellent job in navigating you through that, and the Q&A, and if then go here, and if not go here, that I think you'll find is very readable and understandable, at least I do. The next thing it also does is guidance in terms of how to document their need, which is extremely important because so many requests may happen orally, where the resident comes into your office and makes these sort of requests or has these conversations with you. I'm not paying this fee. I'm not paying this deposit. This is an emotional support animal. And the HUD guidance does an excellent job, I think, to helping you document how they need it, what, if any, either prescriptions or therapy or guidance that they're receiving from a medical professional or someone who is giving them treatment or someone who's giving them counseling, and how you can document that to make sure that not everybody who says, well, it's an emotional support animal necessarily qualifies, because the material, the basis that they may produce is not legitimate. It's not submitted in good faith, because there's a very fine line in emotional support animal world between outright fraud and engaging services of people who don't even know this person as a basis for having an emotional support animal. One of the most clear examples that I think many of you have seen before is just log onto this website, pay this fee, and boom, you have an instant emotional support animal. Look at my certificate. And that passes an essential element that HUD was hitting on of someone's request, which is there a need? Not that someone has a certificate saying this is a certified animal. They're missing the boat because they're putting the cart before the horse, not to get too deep in the weeds. You know, the horse and the cart before the horse example is there even a disability? If there's not a disability, there's no reasonable accommodation. You don't go from 0 to instant emotional support animal by virtue of a certificate. There has to be an established need, an established disability that the animal is there to provide. If you don't even have that, you don't even get to whether or not you have an emotional support animal. That's part one. Of course, and even if you do establish that need, you can document how it is that is established and the legitimacy of the documentation. The HUD guidance is excellent for walking through how you document it, and the need for documentation outside of the HUD guidance is so critical, because you have to document it assuming that every case could be a possible complaint if the resident didn't think you handled it correctly, or thought that you were a passive aggressive against the whole idea, and therefore, in their mind, discriminating based on disability. The paperwork, the documentation is critical for that, to provide in your defense should there ever be a fair housing complaint relating to that whole transaction. HUD's guidance on how to document and when to, and what forms of documentation are acceptable is excellent, and I do recommend reviewing it. Again, that would be a separate seminar where I could break it down point by point, but I'm showing roughly 5 or 6 minutes before 12, and I want to be sensitive to y'all's time.
We do have one question, Will.
Please, hit me.
Do you have an opinion on how pet screening limits our liability for assistant animals?
Say that one more time, how pet screening?
It says, do you have an opinion on how pet screening limits our liability for assistance animals?
Now, I'm assuming for the sake of the question that screening would be more along the lines of what some people would consider dangerous animals, pit bulls, Rottweilers, etc. Is that what we're talking about, breed screening?
To whoever chatted that, could you add a little bit more specific to the Q&A?
I asked the question with another question.
Petscreening.com.
Okay.
That's what she's referring to when she says pet screening.
Not familiar with petscreening.com personally.
Okay.
And I guess that it's based on what the service would provide. And that I can't comment on it blind as much as I'd love to.
Okay. That's the only question I have. If you guys have any questions, please make sure you put them in the Q&A. We do have a few minutes. And while we're waiting to see if there are any more questions, Will, did you have any more slides that you wanted to continue on?
Yeah, just real quick.
Sure.
Just to emphasize one last piece of emotional support animals, sort of a takeaway. Just remember, when you do establish that there is an emotional support animal in play, just remember they're not considered pets at this point. And once that's been established, once you have a disabled resident who's actually made an emotional support animal request, it's legitimate. You've documented it. It's qualified. Remember, at that point, you can't charge any fee or rent for the privilege of having that animal. You can't charge any deposit for having that animal whatsoever. Think of it this way. That animal now is a form of therapy or treatment for that person's disability. It would be like charging someone an eyeglasses fee or, a walking cane fee or a wheelchair fee. It's just not done. And so once they qualify in that regard, fees and rents and deposits are out the door. Now, can you charge the resident damages for damages the pet causes? Absolutely. The Fair Housing Act doesn't absolve them of financial liability caused by those pets. You certainly can. And also, the Fair Housing Act doesn't absolve them and protect them if that pet turns out to be a danger to others. That's one of the clear exceptions of the Fair Housing Act, that whenever a reasonable accommodation that creates a direct threat to the health and safety of other people, it's no longer reasonable. It's no longer reasonable. A lot of people forget the word reasonable when they say reasonable accommodation. It must be reasonable first, then an accommodation. If a person has an animal who's attacked or hurt another person, that no longer is reasonable, and that animal can be required to leave, because it's no longer now an emotional support animal. It was when it played nice and it didn't hurt anybody. But as soon as it did or threatened someone, that became fair game to remove them. They're no longer a reasonable accommodation. And I could talk about emotional support animals all day, and I think y'all can too. But that was the last slide. Other than here's the first page of the FHEO notice from January 28th. Again, please, I invite you to Google it, look it up, and read it. It's it's a little bit easier reading than you might expect of a legal document. It's meant for training purposes, and I think it's excellent for that. And NAA has its own published comments on it as well that I think you'll find helpful. In terms of references, and I'm going to throw this. Whoa. Let me get back. In terms of references, I'm just going to leave this screen up as long as I can, since this is being recorded for these links. You'll see Section 4024 is a copy of the relevant section of the CARES Act for moratorium on evictions and late fees for covered properties. NAA's best practices in the new world of CARES, and that's also a link on their website as well as NAA's payment plan agreement and their waiver of late fees notice. Excellent resources I referenced earlier. HUD's statement on fair housing and COVID that I talked about earlier, and Fair Housing Month announcement and their sexual harassment announcement as well. All links that you can hopefully screenshot, save, look up. There was a recent HUD settlement involving sexual harassment out in California. That's very a nice warning for those who are concerned about sexual harassment in fair housing. It shows you what the price tag could be, well over $60,000 for an incident in that case. Emotional support guidance that I just mentioned, there's a good copy of the link in front of you. And LopeSac Brownlee also has a huge archive for its clients. Many of you on the webinar may be. Really easy to access using your login. We have our own archive of best practices along a lot of these lines that we've covered today. I know we're already hitting 12, but are there any other Q&A?
Yes, we have 2 more questions. I know that some of you may have to drop off, but we'll try to see if we can get these questions answered real fast.
Sure.
The first one is what if you have a resident tell us that they no longer want to pay for pet rent, and then they provide documentation? Is there anything we can do about that?
So you charge them pet rent under the example, and then they want to bring documentation of their reasonable accommodation request?
Yeah, it says, what if you have a resident tell us that they no longer want to pay for pet rent, and then they provide documentation? Is there anything you can do?
If they provide documentation that establishes that they have a disability, number one, and this is very simplistic, but if they say, well, I want a waiver of that pet rent because I have a disability and this is my emotional support animal, and here's any documentation that you normally require that HUD would suggest under its guidance to establish. As soon as they present that, pet rent's out the door. I would waive it. Even past pet rent, their reasonable minds can differ. Like, what if they've accrued pet rent or they've accrued fees they may have been charged for a month or 2 before they made that request? It's just a fight not worth having. I would waive that and say, fine, if you qualified, you're disabled, and you've established that this is an emotional support animal, pet rent's out the door, including accrued pet rent that you could have charged or they were normally liable for, I'd waive it. It's just not worth the return you're going to get on it. And keep in mind, fair housing complaints, for those of you who have them and those of you who haven't, fair housing complaints are so often a knee-jerk reaction to feeling slighted and their rights violated, rightfully or wrongfully. So you're playing the expectations game with the resident who made the request. So when you're dealing with an emotional support animal and a reasonable accommodation request, you're already on the razor wire between resolving this and a complaint. Anything you can do to increase your chances of this just going away quietly and happily, so much the better. So if the resident feels like, wait, I got a deal and I was treated over the top reasonably, I'd do it. It's a good investment. It's much cheaper than a fair housing lawsuit.
Thanks, Will. We have one more question in the chat, in the Q&A. It says that, I know it's a little off topic, but if there's extra time, going back to COVID and effects of CARES Act, is it legal to charge an NSF fee if a property is mandated by the CARES Act? Or do you have a reference of where we can find more CARES Act information like this?
Yeah. Well, if anybody, you'll see it on the recording. If you want to do a screenshot later of the references that I just provided. One of the very first link in that list on the slide was a reference to Section 4024 of the CARES Act. And that has to do with the 120-day moratorium for covered properties, which takes you between March 27th and July 25th. And the short answer is, it says you can't charge any fee or penalty related to the non-payment of rent. Let's think about that. What's the only thing they wrote the check for that bounced? I would bet that 99.999% of the time it was a check they wrote for rent. If it bounces, then that means, and you are eligible to charge an NSF fee, that fee is related to a bounced check that was related to the payment of rent. That's covered by Section 4024 of the CARES Act. I would not charge an NSF fee any more than I would charge a late fee or attempt to evict if you are a covered property. Again, I can't emphasize this enough. Only for covered properties. For properties that are not covered by CARES, you're still able to charge NSF fees, late fees, whatever you'd like. You're not under any restrictions under CARES. But for CARES properties, I would not charge an NSF fee. That would be my short answer. Hopefully that helps.
Thank you, Will. That looks like we have answered all of the questions we had in the Q&A. So first of all, I have to offer you an apology. I did not properly provide an introduction for you when we launched this call. So if anybody is not familiar with Will Brownlee, he's an attorney that's licensed in North and South Carolina. He's the co-founder of two law firms serving landlord clients, Loebsack and Brownlee PLLC and Brownlee Whitlow Prate PLLC. Over the course of the career, Will has focused almost entirely on the aspects of landlord-tenant law, including evictions, fair housing, general advice, and legal compliance, legislative lobbying, and lease drafting. And all Will has served in the rental housing industry for the last 23 years. This is a fun fact I didn't know. So though retiring from private practice law in late 2015 to become the executive director and general counsel for the Apartment Association of North Carolina, I did know that part, but this part, and then unretiring in 2019 to serve as of counsel for the two law firms bearing his name. They're primarily focusing on eviction representation on behalf of Loebsack and Brownlee clients in South Carolina. Will currently resides near his birthplace of Charleston, South Carolina. Will credits his wife, a property management professional who he referenced in his presentation today, who leased Will his very first apartment, for introducing him to the rental industry and for teaching him almost everything worth knowing.
Almost.
So I wanted to share that because I apologize. I did not say that at the beginning.
That's okay. I'm just a guy, a guy that the WAA found to teach. So I appreciate the opportunity, guys. I really do.